SJC-11412, Commonwealth v. Donna Shea.
Yes, counsel, let's proceed.
Good morning, and may it please the court. My name is Jinho King, and I represent Ms. Donna Shea. We're asking the court to reverse your conviction for 3 reasons related to the jury instructions in her case. Specifically, first, that no accidental contact instruction was given. Second, that no specific unanimity instruction was given. And third, that no instruction was given concerning the intent required for violations of New Hampshire protection order. Now,
Which law governs here? Which law governs?
yes, so Ms. Shea was charged under a Massachusetts statute that criminalizes violations of domestic protection orders, but also foreign protection orders. So certainly Massachusetts law would apply, but when we're looking at these out-of-state protective orders, we also have to look at the context in which they're given, because the Massachusetts statute specifically says that there has to be a violation of that out-of-state order. And if we're to look at whether or not there's a violation, we obviously have to look at whether or not the order has been violated. It sounds tautological.
But would that mean that police officers, when they're enforcing these orders, would have to know the laws of the 50 states, Puerto Rico, and Washington, D.C. to be able to enforce them?
No, I don't think necessarily it would, because they would, I think the laws of our many states are actually very similar. In this case, I think it would actually be a much closer question if, for example, an accidental contact instruction was given, because New Hampshire, as the order itself states, it requires a willful violation for it to be criminal.
But if you, I mean, could you say that the violation of the order, and the order says no contact between Ms. Shea and Ms. Frawley, so that's the order, and, I mean, this is the Commonwealth's position, I take it, and that's what we give full faith and credit to. It doesn't tell you that you can't use the Massachusetts 209A standards to decide whether there was a violation of that New Hampshire order, does it?
It doesn't say that you cannot use the Massachusetts standards, but I think that the language of the order itself is telling. And certainly when you have a judge in a different state making an order, they're
And
thinking
the order,
about
what
the
does the order
context.
say? What does the New Hampshire order say?
The order says, so there is...
Not what the statute says, what the order says.
Right. I believe it's all willful violations of this order
That's not,
constitutes criminal.
I mean, the order should be, you can't do this.
Oh, yes. So the order, right, there was no contact, and you know, the whole litany of
Things you can't do, right?
things you can't do, absolutely. But at least domestically, I don't think there's much of a question that you will not be convicted if there was accidental contact. You go to the grocery store and you see the other person there. If you turn around and leave, that's not a violation under our statutes. That may be a factual question, and that's why we want to present the facts and the appropriate instructions to the jury. And that's why in this case, we think that without a full accidental contact instruction, the jury could have found that there was contact that may have been incidental, but would still be a violation.
When you look at the judge's incidental instruction, I agree that the accidental instruction is muddled, but his incidental instruction is quite good. And isn't that essentially the essence, since there was no objection here? Doesn't the incidental instruction essentially said that if it happened that they just ran into each other in the courthouse, that's incidental? Isn't that, for all practical purposes, the same as accidental here?
I don't think that it is exactly the same. And the reason why it's not is because incidental contact is limited to what's necessary incident to a legally permitted activity. So if,
But I thought he spoke about what happened after didn't he also go into what happened after the hearing as incidental? In terms of meeting in the hallway or something like that as you're leaving? Wasn't there some reference to that in the judge's instruction?
yes, I think there were a couple mentions to it. One was saying that essentially, if you're in a courthouse, it's not accidental contact. With incidental contact, I don't believe there was a specific address to whether this would qualify specifically for incidental contact, because the instruction generally is that it's what's necessary. And there was an instruction that if you're in the courthouse and you're waiting beside the person that has that order against you, that is not incidental, because you could be waiting somewhere else, right? Because with incidental contact, you may know that that person is there, but that is still not a violation. With accidental contact, which is what we're saying is appropriate here.
So what is accidental? Accidental, I take it, means that the defendant did not know and could not reasonably have known that the protected person would be present. That's accidental? How does that help you here?
Yes, I think that it helps us in the context of the interaction in the stairwell. Ms. Shea goes to the stairwell essentially to avoid the other person.
That's her testimony.
That is her testimony, yes. And her testimony is important because
She goes to the stairwell to look at her emails or get her
her
messages.
text messages with her daughter. That's correct. She steps outside the courtroom. Her testimony is that she steps outside the courtroom. She's checking her text messages, realizes that Ms. Frawley will be coming out at any moment, and then she removes herself to the stairwell where she does not believe that Ms. Frawley will be, and there's no indication that she should expect to know that Ms. Frawley will be taking that stairwell.
And
As
then
soon as she learns that Ms. Frawley does take that stairwell, when she hears Ms. Frawley's voice, she leaves, which is what we ask of people who have orders. When you find out that that person is there, you leave.
But she said she left. The other person said she pointed the cell phone at her and
Yes.
say, now everybody will know who you are.
Yes, but I think what's important in the context of asking or having an instruction like this given is whether the evidence can support an accidental contact instruction. And absolutely, I think the evidence can support it.
So if the, as Justice Gant said, the muddled instruction on accidental contact were not muddled, would that solve your problem?
Yes, I think it solves a tremendous amount of the problem. And certainly, if an accidental instruction was appropriately given, then assuming the
then
jury
the issue
follows that
about New
instruction.
Hampshire law sort of goes by the by, because our own law is consistent with that.
Yes, I believe that in the context of this case, it would solve that problem. And it's simply because, as we argue, the New Hampshire statute and the context of the orders requires a knowing/willful violation.
But I guess let me put it this way then. Let's assume this were we didn't have a New Hampshire at all. But as you say, certainly our case law suggests that accidental contact in terms of not expecting somebody to be there and when you find out leaving, it would not be a violation. Your client's version of the stairwell contact would have triggered a need for an accidental instruction under Massachusetts law.
Yes, yes, that's our position. And as we argue, we believe that that instruction should have been given because the jury may have believed her. They may have completely disregarded what the alleged victim testified to concerning the stairwell incident, but still found her guilty because there was no guidance as to
So as I understand how you've just answered Justice Botsford, if an accidental instruction had been given here under Massachusetts law, there would be no difference between the substantive law of New Hampshire with respect to a violation and the substantive law of Massachusetts with respect to a violation?
I think that there would not be a substantial risk of a miscarriage of justice to not give an instruction concerning the intent required under New Hampshire law, because
There would still be a difference? I mean, New Hampshire law, as you properly point out, requires a knowing violation, which means a willful violation, which, as I understand it, means that the person is aware that their conduct would be violative of the order. Is that right?
That's my understanding as well.
That's not Massachusetts law, is it?
That is not, no. Massachusetts simply requires that you know that there is an order, and in some ways they just say if you have received the order, you know what the order is. And
Can't be accidental, and that's
right.
You say, so if an accidental instruction had been given here, while there might still be a difference between New Hampshire and Massachusetts law, it wouldn't be a substantial risk of justice in this case.
that's correct.
Okay.
Counsel, do you agree, does your client agree that she took a photograph?
The client does not agree that she took a photograph. I think
Was there any evidence?
Was there any evidence that she took a photograph?
Yes.
No. So just other than the testimony of Ms. Frawley. Ms. Frawley testified that she believed Ms. Shea took a photograph.
But your client also testified or showed to the jury that, at least in she testified, her phone didn't have the capacity to take a photograph?
That's correct. That's what her testimony was. There was also a proffer of evidence that she, because they knew each other for so long, that they had plenty of photographs of each other. Ms. Frawley, on cross-examination, denied knowing whether or not Ms. Shea could possibly have had photographs of Ms. Frawley. But again, there was no specific evidence that an actual photograph was taken, just the allegation that she believed that Ms. Shea took a photograph in the stairwell and said, now everyone knows what you look
What
like.
was the, this is not related to the issues here, I know, but what was the, since these are two women who actually live in different states, they're not, except for a very tangential relation, how do you get a 209A order out of this? Or was it a 258, was it a harassment order?
So there was an order that was received by Ms. Frawley in New Hampshire.
Right, and which,
Right.
is it the same relationships that has to be as the basis of that?
I don't believe that there has to be the same blood type relationship or family ties, that kind of thing that 209A requires. But there does need to be some kind of pattern of conduct, for example. And that was the basis for which Ms. Frawley obtained her order.
Okay.
And then it was enforced in Massachusetts under 209A, I think simply because the
Yes,
statute is broad enough to encompass
Didn't your
it.
client also, she got a 209A order, or tried to?
She tried to get an order, yes.
So what was the basis of the 209A order? That's what I don't understand.
If it's not in the record what the basis for her trying to obtain a 209A order or a 258E order. My understanding is that perhaps it was the relationship through whom she termed her son, who was actually her nephew, that it was her nephew who was married to Ms. Frawley. And at trial, she referred to him as her son, even if they're actually not related, mother and son.
The statute that speaks of other jurisdictions' orders said that it must be, quote, enforced as if it were issued in the Commonwealth. Does that not suggest that we should treat a New Hampshire order as if it were issued in the Commonwealth and therefore enforce it as if it were issued in the Commonwealth?
I think that that's a good indication that we need to look at the order very carefully, because when you have a judge ordering really anything, we look at what that order is. And again, I think the context of the order is important, and the context in which the judge is formulating whatever he or she is ordering is important. When you have a New Hampshire judge ordering, what is allowed and what is not allowed, then we have to look at the context in which these sets of behaviors are allowed or not allowed. And so, yes, we can look at how that would be taken if it were a Massachusetts judge, but I think a judge in the Commonwealth could argue or order that you are permitted to have certain kinds of contact, but you're not permitted to have certain other kinds of contact that are non-accidental and non-incidental to permitted activity.
Well, what if a Massachusetts court issued this order exactly as it is written, and it says a willful violation of this order is a crime? right, well, actually, Massachusetts doesn't require a willful violation in these terms. So would we say, well, never mind that? Under Massachusetts law, there are 4 elements. If you knew there was an order and you violated it, that's tough.
Right. I think that that's probably what Massachusetts
What
order
you
would
would do, you would discount this? If it were Massachusetts order that for whatever reason said that, you would say, well, that
Well,
doesn't
I don't
count?
think that you could disregard that because that's part of the totality of the order. The order is being issued with that as part of the context.
Okay.
Counsel, your time is up.
Thank you.
Thank you.
Good morning, Your Honors. Pamela Alford for the Commonwealth. All 3 issues center around what the Commonwealth terms as a revisionist history of how this case was tried and how the judge instructed. This was not an accidental conduct case, either as it was tried or as law holds. This was an incidental conduct case. And I do agree that accidental and incidental conduct is not synonymous. Incidental conduct not only fit the conduct here, but was a better instruction for the defendant than an accidental conduct. An accidental conduct,
But there are 2 pieces here. There's obviously, you're right, the incidental exclusion clearly applies because this was a court proceeding, and if it's incidental to a court proceeding, then it's not a violation. So that instruction was well done and clearly applies. But the confrontation, I assume, which is the heart of the violation, takes place in a stairwell where the door opens and they confront each other. Now, why wouldn't that be accidental? Why wouldn't that at least raise the issue of whether that contact at that point after the court proceeding was accidental?
because the accidental conduct instruction implies where the defendant did not know and could not reasonably know that the victim would be present.
Would
She
be
knew
coming through the door,
a minute after the court proceeding.
through the stairwell.
The stairwell. The testimony was that there was the stairwell. Certainly, you could reasonably infer, and the defendant so testified that she thought the victim would be leaving the courtroom.
So this stairwell is not separate from this is not a separate stairwell? Everybody has to go through this stairwell to go down to the first
You
floor?
could infer that from the testimony. It was not clearly stated, but you certainly could infer from the testimony in both counsel's closing argument. They kept referring it to as the stairwell, and that both counsel referenced that the jury probably went through the stairwell. There was also an elevator, to be clear, that the defendant testified that she went up to that morning. But the evidence was that this occurred immediately after the hearing, that it was close in time to the first contact that the Commonwealth alleged, which was as the defendant left the courtroom with a court officer. She stopped, turned to the victim and said, "Restraining orders are a joke," kept walking out. The victim testified that
Which is the incident that you say violated the protective order?
the Commonwealth proceeded under both violations, but that both, it is the Commonwealth's argument on appeal that this was a continuing scheme, that these occurred about a minute apart, very close in time, that one occurred as they were leaving, one occurred directly after they had left.
Did you say, was there a door, you may have said this, but was there a door to the stairwell?
I guess that was the essence of my question. I'm trying to figure out whether this is a...
Sorry, and you may have said it. I'm
No, I
sorry.
didn't, but that's exactly what I was trying to get to.
The stairwell was described at transcript 56 through 58 as the victim testified the bailiff came in, that after Ms. Shea left, the victim was there for probably not even a minute. The bailiff came in, escorted her and her sister out. She was questioned, so the bailiff escorted you and your sister out to the stairwell. Page 58, question, where's your testimony that Ms. Shea was standing beside the door, behind the open door. And page 58 goes on to talk about that there was an open door to the stairwell. I also have that page 88 through page 89 contains further description of the stairwell. So under an accidental conduct instruction, the jury could have inferred that once Ms. Shea knew that Ms. Frawley was there, she had to take all steps to leave. That's what an accidental conduct instruction is. And by Ms. Shea's testimony, she stood in the stairwell because she wanted to text her sister. An incidental conduct instruction quite properly says Ms. Shea was there for a hearing. Ms. Shea had a right to be there for a hearing. It certainly gives more credence to the fact that she stopped on the way out, tried not, according to Ms. Shea's testimony, which was wholly contested, that she stood at a place where she thought the victim would not see her. So that's not accidental conduct. She knew the victim was coming out. She was trying to, in her testimony, comport herself with the law. And then there was no interaction. She just heard the victim contact a court officer about something about a picture. That's her wholly contested testimony. That is the epitome of incidental conduct. And because that is incidental conduct, the defendant was not entitled to an accidental conduct instruction. Commonwealth agrees it was not a robust accidental conduct instruction. It did note that accidental conduct was not included. It did note that it had to be, that the defendant had to intend to be where the plaintiff was, a scene that was picked up again in the incidental conduct instruction. So it's just folly to suggest, particularly where there was no request for instructions. The defendant was perfectly happy with the robust incidental conduct instruction that was given, that this should be now looked back to see that it was an accidental conduct case.
Am I correct that the judge said as part of the incidental conduct instruction that if she were standing in good faith in the hallway, it is not a violation, but if she intended the contact, it would be?
Yes, it starts at page 120 of the transcript, and this is, well, not word for word perfect, substantially very close to the model jury instruction for district court on incidental conduct, which uses that example, and that example is if before the hearing there's a public hallway, there you can stand in different areas and not violate it, but if you come and stand right next to the victim where there's plenty of room, you intend to stand next to the victim, then that would be a violation.
Or waited for the plaintiff when the subject could have stood elsewhere.
Yes.
Is that what you suggest happened here?
Certainly that's what the Commonwealth is suggesting.
That she waited for the plaintiff when she could have stood elsewhere.
Well, even more than that. It's not just that she waited for the plaintiff, that she caused a direct intentional confrontation with the victim by flashing her cell phone in the victim's face and at either taking or simulating to take a picture and saying everybody will know who you are. So it was highly disputed what happened to the stairwell, but the defendant, in the light most favorable to the defendant, she got the instruction that would have exonerated her conduct if the jury had credited it. Obviously, the jury did not credit it.
All right, let's talk a little bit about New Hampshire law and this whole concept of a willful violation of the law being part and parcel of New Hampshire law and not really part and parcel of ours.
Massachusetts approaches it differently. It is clear that Delaney says that the knowledge is of the order, but cases such as Kendrick and Finay's, Raymond of the appeals court says that the legislature was not intending to punish mistakes or accidents. So, and if you look at the model district court jury instruction, which the Commonwealth would concede that part was not given here, it talks about, have you found whether the question is whether the defendant knowingly violated an abuse prevention order. Here, the defendant committed the violation of the abuse or the stalking order, as it's called in New Hampshire, the foreign order, in Quincy District Court, in Norfolk County, in Massachusetts. She was charged not with violating New Hampshire law, she was charged with violating 209A, Section 7, Massachusetts law.
She was charged with violating an out-of-state order.
Under Massachusetts law.
Right, violating an out-of-state order, and the out-of-state order said that a willful violation of the law is a crime. So what you're saying is, no, in Massachusetts, it doesn't have to be a willful violation to be a violation of Massachusetts law. So we discount New Hampshire law.
Basically, you take the text of the order,
Yes,
you cannot do X, Y, and Z,
yes.
and you transform it as though it had been issued by a Massachusetts judge in a Massachusetts court, and you enforce it in that way. That's your
Yes.
position.
And you discount the language of the order that says a willful violation of this order is a violation of law.
I don't know that you need to discount it in every circumstance. I think there are two questions here. I think there's the question of what law do you apply, and there's the question of notice of the terms of the order under Massachusetts law. You apply Massachusetts law to violations of Massachusetts law. The law that was violated is 209A7. To the extent that there may have been a notice issue, that was something that
It's not a notice issue. Not a notice in the sense that I didn't know there was an order outstanding, or I didn't know what the order said, is
she knew what the terms of the order was. She admitted on cross-examination that she had read the order, that she knew what the terms of the order are. So it is correct to say that in this case there is not a notice issue. You apply Massachusetts law to the violation that happened in Quincy District Court. The text of the terms of the order, do not contact, do not stay away from. Those are what's given full faith in.
So under New Hampshire law, I think the instruction was, you must find beyond a reasonable doubt that the defendant acted with awareness that her conduct would be violative of the order, that her conduct in the stairwell would be violative of the order. You must find beyond a reasonable doubt that she acted with awareness of that. So that would be the New Hampshire instruction. Is that the Massachusetts instruction?
I think Massachusetts approaches it differently, but to get to the same point. I think the incidental conduct instruction, which talks about that has an inference that there has to be an intent to do something other than what you are lawfully and legally permitted to do, gets to the same point as the New Hampshire instruction in different words.
I'm not saying they're not close, but there is a nuanced difference, isn't there, between Massachusetts law and New Hampshire law on this subject?
Yes, and to the extent that the two laws may have different nuances, the defendant didn't violate New Hampshire law. She violated Massachusetts law.
It's a violation of Massachusetts law to do what? To violate an out-of-state order?
Yes.
Okay.
Is it a defense?
it's
Is
not-
it an affirmative defense in this case, the New Hampshire order as it's enforced in Massachusetts? Is it an affirmative defense for a defendant? Is an affirmative defense available on grounds that there was no knowing and willful violation of the order?
I think in an appropriate case, it goes that you could, that under Delaney, it says you have to have notice of the terms of the order. The defendant might say, these are the terms of the order that I had notice of. It's not an affirmative defense in this case for a couple of reasons. One, it was never raised. Two, she's conceded she had notice of all the terms of the order. It was never a question of whether it was a knowing violation or not. Either you believe the defendant who said, I didn't speak to the, or did not say that she did not speak, that she spoke to the victim as she was leaving the courtroom, did not say that she said that she did not interact with the victim in the stairwell, or you believe the victim that says that there was this contact as Ms. Shea was leaving, and there was this contact in the stairwell. The defendant never claimed that there was any ambiguity as to the terms of the order in this case. So even if there might be an appropriate case that be an affirmative defense because of the language of the order, there's just no substantial risk here because of the way that the case was tried in the defenses and by the parties.
But your position, I gather, is that if you had an order, or 298 order or the equivalent from a state with a very tough intent requirement, you could be guilty of violating that order in Massachusetts, where if you committed the conduct in that state, you may not be guilty.
Absolutely, yes, because you're violating Massachusetts law by a foreign protection order that's given full faith and credit in Massachusetts, that is treated in Massachusetts as it was issued by a judge sitting in Massachusetts.
Well, that's not full faith and credit. Full faith and credit means you essentially enforce the law of the other state in your state.
I think you enforce the judgment. The judgment is do not contact the victim. The judgment is do not stalk the victim. Do stay away from the victim. Massachusetts, and if you look at, I believe it's Record Appendix 10, it talks about that this could be enforced in other states. The defendant violated Massachusetts law.
But do you get there through the full faith and credit analysis or through the sort of conflict of laws analysis? Which law should
Or you may
apply
get there through the statute.
under the restatement?
I get
through the
Justice
language of
Foster,
Section 7, right?
Precisely. I get there through the statute. There's nothing further.
Thank you.
Thank you.